Thank you very much, Michael. A glowing introduction as always, and thank you all very much for being here this morning with us on this Monday morning for what has now been called the Barn Burner discussion on Procedural Order Number 1. Now, Procedural Order Number 1 is a sample procedural order that is attached to the new ADRIC rules, and we're going to talk about that today as well as a little bit of background on the new ADRIC rules. So to that end, you should see, oh, we don't have it up. You will be able to Google the new ADRIC rules. A quick Google search of ADRIC rules will take you right there. Once you're there, there is a bookmark at Appendix R3, and that's the sample procedural order that we are going to talk about here today. Before we get into that, I'd like to briefly set the stage and give you an overview of the new ADRIC rules. So the previous version of the ADRIC rules was in effect from December 1st, 2016 until February 28th of this year, when of course the following day the new ADRIC rules took over. Now the previous rules served the Canadian arbitration community well, but a lot has changed both domestically and internationally since the time they were drafted in 2016. So the new rules aim to modernize the previous framework and provide a full, fair, and final framework for resolution of disputes with selective access to institutional support when needed. Now, this work was completed by two groups over the course of 2 years, many meetings, and several lively discussions. The first group was the Rules Committee group, which consisted of 13 arbitration practitioners from across Canada, myself and my co-panelists included, and many of you or others may be in this room here today. We also had an advisory board led by Bryan Casey, Megan Keenberg, Jack Marshall, Eric Morgan, Murray Smith, Doug Stollery, and the Honorable Justice Neil Whitman. I'd like to take a brief pause here and make a special thank you to Bill Horton, who chaired this project with his signature mix of wisdom, vision, and tenacity. And Bill, thank you very much for that. Bill has described the new rules as a framework for full, fair, and final resolution using up-to-date arbitration procedures and streamlined institutional support when needed. And we think that sums it up perfectly. So what's new? A few key updates. The new ADRIC arbitration rules, unlike the previous rules, no longer make a distinction between domestic and international arbitration. So the default position under the previous rules that you'd kick out to the UNCITRAL arbitration rules no longer applies. And of course, that was taken into account in the committee's work in drafting the new rules. With this, we also see a flexible, a la carte menu of available institutional support, meaning that parties can pick and choose the extent of the institution's involvement and tailor that to their needs in any particular dispute. We also have updated and what we say are improved arbitrator appointment procedures, as well as an optional, limited, and integrated right of appeal. Now, in addition to this, we also see a user-friendly precedence. So there is a checklist for the first procedural meeting, as well as a sample first procedural order. So of course, what we're here to talk about today. Now, we don't have time today, unfortunately, to talk about all of the changes to the rules, but certainly ADRIC wants your feedback. So if you have any comments on the rules, any suggestions, thoughts, please share them with us throughout the time we have here together, or you can share them with ADRIC by emailing the executive director. And that email would also be available on the ADRIC's website. So, with that, I'd like to turn it over to Bryan, who's going to give us a brief overview of Procedural Order Number 1, as well as the rationale for including it in the new ADRIC rules. Bryan?
There we go. Thank you. It will be very brief. I'll just give a really quick overview of Procedural Order Number 1, just to provide a roadmap so that we can dig into some of the discussion. And what we're hoping to do, it's a good-sized room, so let's get some discussion going. There's so much experience in the room here. so many views, and this is a topic on which everybody will have had experiences, and so what we're trying to do is get a discussion going in terms of what the procedural order number 1 does, but it's really just a sample as a starting point. And so that's the main point that I want to make in terms of the overview as to what procedural order number 1 does. It's an appendix of the rules, but it's really there just as a sample that should really be customized for the given dispute. And really the main goal of procedural order number 1 that's appended to the rules is to try to design and set out a process for a commercial arbitration with a view to getting it completed from beginning to end within 6 months or 12 months, in that range. And where you fall within that range will be a function of the choices that you make in terms of the process that you design and how you sequence it and what parts of it you include and don't include and all those sorts of things that we're going to cover off in some more detail as we get into it. But that's the main idea behind the sample procedural order, and that's the goal, and so that goal will infuse some of what you hear from us in the discussion today. In terms of the overall flow, it's not surprising. It really just follows the usual process that we see in commercial arbitrations. You start with some statements of position or pleadings as they're referenced in the ADRIC rules, and then from there moving into an exchange of witness statements, including the reliance documents appended, and then disclosure requests are either before or after or somewhere in there. In terms of the process, and I'll come to that in a moment in terms of what I just alluded to, and then expert reports, and then the hearing. And so really those are the main steps that we all see in a process, and these are addressed in the procedural order, which I think is one of the benefits that we see from arbitration, is that you set your hearing date, and hopefully you do that on a date that's not too far down the track, and then everything else fits within that envelope, and you just make it work and get it done. So that's the idea of the procedural order. Really, it's driven by an evidence-first perspective, as is the international commercial arbitration approach, and that assists in being able to cut out a number of pieces of process that might otherwise be necessary or desired in a dispute, and helps achieve the goal that I referenced earlier. There is, as Emily mentioned, a checklist that's part of the ADRIC rules as well. It's one of the other appendices, and it's helpful to review the checklist in conjunction with the procedural order. These are resources that are designed to try to help parties and arbitrators and counsel think about what needs to be done and addressed at the beginning of the process, so that it's all laid out and everybody knows what's going to happen and in what order and when. So with that, I think that's the overview that I was thinking to provide, but again, I just would leave it that hopefully we'll get some comments and some experience sharing as we get into some of the topics here.
Thanks, Bryan. So I think that's a pretty good overview of the sample procedural order to the rules, and it sets the stage for the next part of our panel, which is the fun part for me, where I get to ask Stephen and Bryan and the audience all of the tough questions. So I will tee up with an issue that we see in practice. We'll hear from Stephen and Bryan, and then we'll turn it to the audience, and please don't be shy. We really do want to rely on the brain trust that we have in the room here. So first and foremost, let's start with what might be a bit of a hot topic: witness statements and direct evidence at the hearing. The procedural order discourages the delivery of direct evidence at the hearing. The idea is that you deliver your direct evidence by way of witness statement, and that's it. So, Stephen, can you kick us off? What are your thoughts on live direct evidence at the hearing?
I hate to be boring, but or overly lawyerly, but frankly, in my view, it depends. Right? I understand, of course, and I think it's good practice. It's certainly accepted practice in most cases that direct evidence takes the form primarily of witness statements. But I happen to believe that there is a role, a limited role, but an important role for live, direct witness evidence at a hearing, in particular and specifically to respond to whatever last statement might have been made by an opposing witness, to give a witness a chance not just to say, hello, this is my name, yes, I confirm my affidavit or sworn statement, but to give the witness a chance to respond live in direct to the last statements made by other witnesses before the witness is tendered for cross-examination. And of course, you're right that the procedural order and the rules tend to suggest that that is a secondary role for the witness. But I'd like to point out what I consider to be probably the most fundamental aspect of the ADRIC rules. And this is not, ce n'est pas sorcier. It's not rocket science. It's not particularly unusual. But it's the provisions of the rules 4.92 that effectively says the tribunal has all of the power necessary to conduct proceedings in a way that it determines appropriate for a fair and effective resolution of the dispute. And much of what I'll have to say today, I think, in response to questions, flows from that. It's an it depends sort of statement which allows the tribunal and the parties to adapt to circumstances. Voilà.
Bryan, any comments?
Yeah, as usual, I can't help but agree with what Stephen says. And I think what we're really talking about is just when it depends and what's the default and the usual rule.
Right.
And I do agree with what Stephen has said, which includes a discretion to deal with more unusual circumstances. I think the general rule is quite helpful because it can prevent against surprise at the hearing and it can prevent against case splitting. And just from a fairness and efficiency perspective, I think it's important to have a process that's laid out and that has a beginning and an end, because if it doesn't have that, then it can be endless sometimes if people are always asking for the last word. But there are certainly cases where it's important to be able to respond, and so having a discretion to depart from the general rule, I think, is important.
May I just add that at least I see it as obvious. I don't know if others do in the room, but I know a lot of people don't see it as obvious. And often there are arbitrators and there are parties who will say, no, a witness on direct is there to affirm her witness statement and nothing more. So it can be a hot button issue, I suppose, in certain circumstances.
And with that, does anyone from the audience want to share perhaps a situation where live evidence from a witness at the hearing either saved the day or backfired? Any experiences in the room? Well, don't all jump at it at once, please.
The microphones are circulating.
Peter.
I've got plenty of anecdotes about witnesses who've been disastrous, but that wasn't what I was going to say. I was going to say that we've had a revision in the English court practice about witness statements. The judges were getting very fed up with overly lawyerly crafted witness statements that went far beyond what could properly go in. So the new rules say that the witness statement could only be what could be properly given in direct evidence. And so you're doing away with the large narrative explanations of documents and all sorts of things that are unnecessary. I haven't seen that practice yet migrate into arbitration, but I think it's a real possibility that it might. So that's just a flag that you might well come up with a slight change to the nature of witness statements. I agree with Stephen. I think it's if that's what you said, that it's very important for some direct evidence to be given, certainly responsive to the latest round of statements, but some sort of general warm-up. And that's generally the standard that I've come across, that most people will allow a gentle warm-up for 5, 10, 15 minutes, probably something of that order, depending on the nature of the witness and what they've got to say, but that sort of thing.
Thank you. Anyone else? Michael?
Just two things. Interesting, Peter. You know, we always seem to follow what's going on across the pond. You know, I'm thinking of the old ANS test that they abolished, and then we decided to adopt it here instead. We're doing the same with the Ontario Rules of Civil Procedure now, speaking of witness statements, where much of the case will be front-end loaded through the provision of witness statements. So that's sort of where the Ontario rules of court are headed, it seems. But on the question, Jim and I were just asking ourselves, when would you ever need to have another last word? Because generally speaking, the arbitration process is that you have your memorials, everything's pre-filed, and then witness, you know, the claimant's witnesses testify, they're cross-examined, and then the respondent's witnesses, generally speaking. So I'm kind of curious, I think it was you, Bryan, who said, or maybe it was you, Stephen, who said sometimes you need to have a witness say something live to have the last word in chief, and I couldn't, in my own mind, figure out what that might be. I'm just wondering if you have any examples or if you've seen that happen, because it sounds kind of interesting.
Well, I'm happy to let Bryan tell you what I meant.
I couldn't do that justice.
I don't think I said last word, and I don't think I said need. In any event, what I believe is that it's sometimes it can be appropriate to give a witness an opportunity, a brief opportunity to testify in chief, as I say, regarding an issue that may have been raised for the first time by a witness on the other side, to whom, let's say, the claimant's witness hasn't had an opportunity to respond, right? The last witness statements that will have come in would have been with, might have been with the other party. And it's possible that that's a subject that won't come up on direct. And if I believe that my witness has something to say on that, I think it's appropriate to put the question to the witness in chief. Or if I'm an arbitrator, I tend to think it's appropriate to allow counsel to do that. Effectively to join issue, if you will, on the facts before cross-examination begins.
I could jump in there just to add to that. I do a lot in the fast track area, and so in some instances the process might be designed where there's no reply witness statements or reply memorial, for instance, just because the time envelope that the parties want to get the thing done within is too short, and so they agree that they're going to have a truncated process. And so it may be that in response something is raised that just wasn't reasonably contemplated in putting the case in at first instance, and so a function of condensing the process down and taking out some steps may be that a proper exercise of discretion would be to allow a brief reply in terms of some fact evidence is what I was thinking about, and I don't know if that matches what Stephen, what you're thinking about, but sometimes that can happen.
Well, thank you all very much for those comments. I specifically appreciate Peter's comments on the length of direct. I know we've probably all seen situations where opposing counsel is saying they need a half-hour warm-up. I don't know if that fits into the warm-up category itself, but anyhow, all good discussion. So let's move on now then to the matter of disclosure, and particularly timing. The Sample Procedural Order tells us that parties can make production requests at any time. Now, typically in my practice, what I've seen is that witness statements will come first, followed by the production requests. But that doesn't always make sense in every case, and particularly where you have cases where you see an asymmetry in the information available to the parties at the outset of the case. I'm thinking, for example, of a case that Michael and I are working on right now. We represent the corporate respondent in an oppression proceeding commenced by the claimant, who is a shareholder and former employee. And his position is that he cannot prepare his witness statement without productions because all of the evidence he would need to support that witness statement exists in his corporate inbox, which he no longer has access to as a result of no longer being an employee. So in a situation like that, it made sense, with a view to balancing that asymmetry in the parties' information, to proceed first with production requests before witness statements. Bryan, have you encountered a situation like this before? And what are your thoughts on when it makes sense to depart from the sequence of witness statements first, production later? What is your experience?
Yeah, I think I'd echo a lot of what you've said, and what I've seen often is that it is more time efficient and effective if the witness statements come first and then the disclosure requests come later. Just to mark it in terms of what the procedural order says on this, in terms of the sample, and again, just to emphasize, it's just there to look at and think about. It's not necessarily the right answer in every case, but what it says is that disclosure requests can be made at any time of the proceeding, and so it does not set a particular sequence. It leaves that either, if adopted with that language, to be made at any time, or it can be modified so that it does happen after witness statements. And I think generally the reason that it's so helpful, and this is just stating the obvious, to have the witness statements first, is that that takes away the need to make disclosure requests to figure out what the other team's case is, because it's been put in your hand with their witness statements and maybe their memorials. And so one of the main purposes of record and disclosure requests has been fulfilled, and your disclosure requests are more limited to what you're looking for to attack a case of the other party, or to prove your own case rather than understand the case of the other party. And so it can really assist in achieving the goal that I alluded to earlier, because document requests, as we all know, can take on a life of their own, and it's not a necessarily happy experience for anybody that's involved with it. And so if we can make some headway in terms of limiting that down by designing the process and a sequence of it that helps with that, then that can be more helpful. But I think it can, in some instances, be important, like Emily alludes to, where there is an information asymmetry, and that can be, for instance, in a construction dispute where you've got an owner who's hands off and it's a turnkey lump sum project. They don't have a lot of insight and transparency into how the project unfolds until it goes badly, and then there's the dispute, and so they don't have a lot of the project record. And if they are the claimant and they are required to provide their memorials first, then that may not be as helpful from the owner's perspective, and maybe not from a general fairness perspective. So that may be one instance where disclosure requests from the EPCM contractor in advance of the owner needing to put its case in may make some sense. I just say may because it doesn't necessarily, especially if there's a right of reply by the owner afterward, maybe it can be addressed at that stage. So those are our thoughts in relation to that. I don't want to get into too much detail because we have another panel coming up soon with respect to record management and fairness and so on, and I'm looking forward to hearing about that too.
Stephen?
I said in response to Mike's question earlier that I would have been happy to have Bryan tell you what I meant. He's just explained exactly what I think about this question. I really have nothing to add to what Bryan said. I would like to point out that one of the virtues, I think, of these new rules is quite intentionally they say expressly what might have been assumed, and there's a virtue to saying it expressly. So when PO1, the sample PO1 speaks of the idea, and the rules speak of the idea of document disclosure being permissible at any time, I think that conveys the idea that you might require not just a different approach in every case, but more than one round of disclosure, which of course is always within a tribunal's discretion. And I applaud the fact that this states it clearly, and I think realistically, depending on the case, there might be a need for more than one round of disclosure.
Thanks for that, Stephen. And I think before we turn to the audience on the matter of sequencing, I'm going to bring us back up another step on sequencing generally of the parties' evidence in the procedural order or under any arbitration. Under the ADRIC rules, Rule 4.7.2 in particular, the presumption is that the claimant will advance all of its initial evidence, including fact, witness statements, and expert statements at the outset, and the respondent will respond in kind. Now, the sample procedural order takes a somewhat different approach, requiring first that the claimant proceed with its fact, witness evidence, responding evidence, then a reply, and a similar approach for expert statements. My approach as of late has followed the shotgun approach. So the parties deliver their initial witness statements at the same time and then follow up with replies at the same time. I found that to be quite efficient, and it works well in your average commercial case, in particular a contractual interpretation dispute, for example. And what I like about that approach is that nobody's really left with the last word. On the other hand, it doesn't always make sense to proceed that way. In particular, perhaps claims of negligent design and manufacture in highly engineered products. Similar to the situation that Bryan raised a moment ago, if you're the responding party, a manufacturer of this product, there are allegations of negligent design. You're not really aware of the facts leading to the incident. You have no insight into the design. In that case, it makes more sense to follow the rules-based approach as opposed to a shotgun or different approach. But Stephen and Bryan, I'd like to hear your thoughts on this. And I don't know that we had the opportunity to discuss the shotgun approach before we got here today, but as I thought about it more, I thought that's something that I'm seeing more frequently, and perhaps it's just something that's comfortable for me. Well, don't fight over it now. No. They're too eager. Any thoughts?
I'm going to be very repetitive. I apologize. It depends. It depends on the case, and it depends, frankly, on the arbitrators as well, and the arbitrator's comfort level. Hearing the parties during a first procedural meeting before a first procedural order is set out. I don't have a hard and fast view. I think it appropriate that the rules set out a presumption, I suppose, and that the draft procedural order set out a presumption. But again, it depends on the case. And my understanding of these rules, my personal intention in contributing to the discussion and the elaboration of the rules was to allow this sort of important question to be determined case by case, flexibly.
I agree with that, and I think, just to give a bit more color around on what it may depend, I think what I've seen, whether sitting as arbitrator, as counsel, that if it's a breach of contract case, then that may lend itself a bit better. If it's not really factually complex, for instance, and it's a breach of contract case, then that may lend itself better to having everything from the claimant first and then a sequenced approach with a response and then maybe reply memorials. But maybe if it's factually complex, then a construction dispute, for instance, maybe it's better to have an exchange of the fact evidence in sequence first and lay that factual foundation before the experts start weighing in with their evidence. And so that would be one example maybe of where it may depend and what's most efficient at the end of the day.
I mean, I know this is standard. Everybody knows it. The point is to think about these things as you file a claim, as you enter into arbitration, as you select your arbitrators, and as you go into this first procedural meeting where you're going to be setting out the rules of the game. Everybody knows this: motherhood, apple pie, shepherd's pie, pâté chinois, but it just can't be repeated often enough. These rules, this procedure generally gives you the opportunity to effect a procedure that suits the case at hand. And If you don't do so, I suggest that as an advocate, you're not doing your job, and if you're not open to it as an arbitrator, you're not fulfilling part of what one's function is.
Yeah, great point, Stephen. I think that that's probably true for all of the topics that we're going to
course.
discuss today, right? As counsel, it's our job to look at the case, see what it requires, and what type of procedure is going to allow our client's theory of the case to reveal itself in the best possible light. With this in mind, I'd be curious to hear from the audience on whether you have a preferred or default procedure for sequencing evidence, whether it's the witness statements, expert reports, and where in that process you typically prefer to see disclosure requests, whether one, several rounds. Anyone have any preferences on this point? Any default positions? Yes, over here. I think there's a mic on its way to you now.
Thanks. Just to be a bit more creative, we've had a couple cases that are very technical, expert intensive, but of course the experts are relying on underlying facts. And so we've actually staggered, like we've had the initial evidence go in, the fact evidence, then the initial expert reports, and then the fact witnesses are able to correct any of the facts that perhaps the experts have misconstrued or misinterpreted. And then you have the reply expert evidence come after. So that was one, that's worked in a couple cases for us very well.
Thank you for that. Yes, Donnie.
So by way of a particular example, I've actually got a case at the moment where one of the key issues goes to authenticity of a document. Our opponent needs the document to have been dated at a particular time when he was still the director of a relevant company. We've actually had some initial ink dating analysis, which suggests the document is at least 6 months newer than that. And now we're trying to agree directions for the full settlement of the evidence to go in for the merits hearing. And the other side, quite interestingly, are asking for expert evidence to go in before fact evidence. No doubt because they want to see what the expert analysis is and then tailor their narrative to it. And so we are actually in the midst now of a bun fight over explaining to the court exactly why we need to have the fact evidence go first. He needs to nail down his story, and part of his story will be, I preserved the document in a certain way, and that's why it hasn't aged in the way that it should have aged. And we say that he should not be allowed to see the expert evidence, even the initial expert analysis, until he has pinned his colors to the mast on his factual story, and then the expert should be able to work off that. You'd be surprised about how much people can come up with reasons why it needs to be different.
Yes, thank you, Donnie. And I think we see some excitement in the audience here about the concept of, did you call it ink dating analysis? That's new to me. Donnie, can you tell us what exactly that means? Are they looking at how the ink has dried over the years?
So I'm no chemist, but yes, effectively, apparently it's a bit like when you paint a room and the solvents, you smell them a lot at the beginning and then it goes down over time. Apparently, because this was not an electronically signed document, it was signed with ink. Apparently, the ink on the page releases solvents over about an 18-month period. And so if you test it now in June 2025, and the one person says it's a year old, but we suspect it's only about 5 or 6 months old, apparently you can see it from the rate at which it is still giving off solvents.
Wow.
There we go.
I'd love to know the pipeline from school to that profession. I wonder how somebody finds their way there. But anyhow, there's a place for all of us in the world, isn't there? Any other comments? Yes. I think we have a mic on its way, just over here in the center, behind the pillar.
Thank you. I'm hiding behind the pillar here. Farley Cohen, and I've acted many times as an expert witness and also as an arbitrator. And from the perspective of an expert witness, I think the timing of exchanging versus replying to each other and the whole structure of disclosure are all very much interrelated. Because as experts, we need that information in order to provide an opinion that's helpful. I would say the trend is more to exchanging reports rather than at the same time rather than staging them, and I think that's helpful. But we need to have the disclosure in order to get there, and sometimes those reports will result in a number of new questions, and the arbitrator's got to say, do I reopen the disclosure, and how are we going to fit that timing into the envelope as to the entire process. So depending on the type of case and the type of disclosure and the balance between the different experts who has access to what information will drive or should drive the parties to rather exchange or sort of stage them one after another. I think it's very much case dependent. Depend is a great word. I think definitely it depends, Stephen. Absolutely.
Thank you so much. Oh, just one right behind you here, Basma, and then Michael, we'll hear from you.
Just following up on that expert comment, I have a standard procedure in my cases which will involve expert evidence of separating the requests for disclosure to the merits and to the experts. Because I have found over time that the job of making disclosure requests is given to junior members of the law team who don't want to leave anything out when they're told by the experts what they might want. So I provide that any requests for documents to assist the experts must be confirmed jointly by the experts as necessary and proportionate to the material they need to do their job. If they disagree, they have to explain why they disagree. And to pick up the last comment, which I think has got great validity, there is an ongoing need, often as experts move through their work, to seek further documents. So they can, through the parties, ask for further documents explaining why, jointly hopefully, they need them and why they're proportionate to the job they do.
Very interesting. I hadn't thought of that approach before. Any thoughts from the panel on the?
It sounds good, Mr. President.
Sounds good.
He's presiding me in a case we just appointed, so I look forward to seeing how that works in practice.
Michael, any thoughts? I did see your hand there a moment ago.
There's a case under reserve right now in Ontario where one of the issues that was argued arose from the sequencing of the exchange of information in the proceeding. And what happened was they had 2 rounds of shotgun, and on the second round, the reply round, the respondent filed an expert report. And there was an objection taken to that and dealt with by the tribunal, but one of the issues under reserve will be whether that was fair, whether it amounted to a denial of justice under Article 34 or whatever. So flagging that only because when you're designing your double shotgun procedure, you need to ensure that you've thought through the issue of expert reports so you don't get sandbagged like these people did at the end of the day. So we'll see what the court says about that, but it'll be interesting to read, I think.
Certainly. I'm assuming we could probably talk about sequencing all day here, but unfortunately we don't have all day with you, so I'm going to move this conversation along. Unless Bryan or Stephen, anything further you want to add on that? Great. So I guess that takes us then to the matter of pre-hearing questioning. Everyone's, well, potentially a very controversial topic in this room. Whether pre-hearing questioning, or as we might call it, discoveries, should be permissible in arbitration. And the Sample Procedural Order tells us that pre-hearing questioning is available in limited circumstances. For anyone looking at the PO, that's a paragraph 22. That would be available only where there's a specific need to question on a narrow and specific category of information, and that information is both relevant and material to the outcome of the arbitration. So Bryan, what circumstances in your view would justify a request for pre-hearing questioning, and should any limits be placed on that besides the limits we see in the PO?
Thanks. I think this part of the ADRIC rules was not an update. The ADRIC rules had a default against pre-hearing questioning in their earlier iteration, and so it's been carried forward, and I think it reflects the general approach that we see in arbitral institutional rules globally, that there ought not to be, as a general rule, pre-hearing questioning. And it's part of what I was alluding to earlier is that if you look at the whole of the process, generally I think you can design it in a way that takes away, if not eliminates, the need to have that, and that can save a lot of time, because if you take out a big piece of a process, then it can get rid of all of the tentacles that might flow from that if there are objections or undertakings or all these sorts of things that we see in court proceedings that we can get rid of in a designed arbitration process. So as a starting point, I think that it's good to have a default against it, and that's generally what I see in the proceedings with which I'm involved. And I think the limits that the rules and the procedural order talk about are good. They can be made more specific if you do need it. I think there needs to be a demonstrated need by looking at the whole of the process and proving that because of this particular circumstance or that, it's necessary to have a certain number of hours, let's say, of questioning before the hearing of a particular witness, and then if it's put in that kind of a context, then you might be achieving a fairness goal without derailing the process. And but I think the other thing that can be considered is, when is that evaluation made? Is it made at the time that the procedural order number 1 is being set, and maybe the steps of the process make it so that it's not necessary then? Sometimes what I've seen as arbitrator is one of the parties is really feeling the need at the beginning to have pre-hearing questioning. But if it's parked and put down the road a little bit, once fact witness statements get exchanged and disclosure requests get made and answered and all that sort of thing, maybe that need doesn't continue. And so if it can be pushed down the road a little bit with a little window left in that schedule in case it does get proven as a need with some timelines around it, then that can be good. One other really minor thing, in setting a procedural order just last week in a case where I'm sitting, the parties had reserved a day each for pre-hearing questioning because they both had agreed that that was what was necessary, and although that's not necessarily my inclination, the parties had agreed, and so be it. But I did suggest that they agree to a certain number of hours so that we didn't end up in a debate about whether a day is 5.5 hours or 10 hours or something like that, and they seemed to adopt that. And so that's one other suggestion just to make, to be a bit more specific about the limits that are being put on this.
Thanks, Bryan. Stephen?
Thank you. Well, you said something interesting. You said lots of interesting things, but 2 points that I'd like to follow up on. One, the idea of setting limits. It could be hours. It could be number of witnesses. Sometimes that's agreed to in advance in various court rules as well in various jurisdictions, in the event that there is to be pre-hearing questioning. But I think it's important also what Bryan said, that it's often not necessary. I think that these rules and any good rules are designed not just with the idea of precluding pre-hearing questioning for the sake of efficiency, but obviating it. In other words, rendering it unnecessary by requiring, for example, the fullest possible statement by a witness in her or his witness statements. And these rules say specifically, everything a witness has to say at a particular point in time must be said in those witness statements. And I think that's a rule that goes a long way toward obviating the need in many instances for pre-hearing questioning. The last point I'd like to say, on which I agree fully with Bryan, is I may have my own views as to, and the rules may have their own views as to how an arbitration ought to proceed and what best practices are. But speaking for myself, I'm firmly of the view, I'm ever conscious of the fact that this is a consensual process. Rarely will I tell the parties, you want it, I won't allow it. And I think that's very important. Parties are allowed huge leeway to agree on how to conduct a case, in my opinion. Thank you.
Thank you both. I mean, I agree. I think, you know, it's another situation of it depends and what does the case need and what do the parties want. Though I do know there tends to be situations where, you know, you hear the word discoveries. And I mean, for me, my reaction is, why? We're in an arbitration, right? I see we have some comments here. If we can get a microphone. Thank you, Basma.
Thank you. This will be brief. I'm Dana from New York, and my experience from some American parties is that what is agreed is not necessarily the most efficient or functional agreement, and I'm interested to hear the panelists or others in the room on how they react to a proposed agreed procedural schedule or timetable that is sort of inherently problematic, doesn't leave time for the tribunal to resolve document disputes, which are anticipated by the tribunal, not necessarily by the parties, and other aspects of the procedure. And I've seen this come up from a lot of different, you know, as counsel, now I'm an arbitrator, but even the discussion amongst the tribunal, you know, maybe, you know, a lot of different ideas are shared on whether we should, you know, embrace wholly or in part what's been proposed, and how do we navigate the areas that we think are going to be problematic in order to protect the hearing dates and the fairness of the procedure. So I don't know, maybe an anecdote or some tidbits on how you navigate when the proposed procedural timetable from the parties is not workable.
I think that's a great question. I think it's probably going to start with gently, navigate it gently where the parties have agreed, but I see Stephen.
Yes,
Stephen has
and no. I mean, I've already flown my colors here. Unworkable is one thing, all right? Long and unwieldy, you know, I'm your servant, not the other way around. And that may be scandalous for many arbitrators in the room. But I feel that there's a huge area where, as an arbitrator, I have no skin in that game. All right? I'm here to tell you what I think might be more efficient. I'm certainly here to tell you what cannot work or will not work in my experience. But rarely do I believe it's appropriate for one or three arbitrators to tell the parties, you cannot have it your way, as long as it's fair, as long as it results in a bulletproof award.
I tend to agree with that. It's a contractual process, and so it's the parties' agreement, and the arbitrator is there to serve. We're service providers. And at the same time, what I generally do if something like that is presented is to try to provide some suggestions. I try to make clear that they are suggestions to be taken or left as they are, but to point out some potential areas of concern, and then reiterate that I'm just leaving them for consideration rather than dictating, because I think when sitting in the role as arbitrator, if you don't make clear that that's all that you're doing, it could be taken otherwise. But I think there's a role to be fulfilled if we see that it's going to be a train wreck because of the tentacles, that we mention that, so that we don't keep that to ourselves and then regret it afterward.
Oh, we have another comment. Sorry. Thanks, Stephen.
Thanks very much. One of the things that I find is that these issues arise most often with really dedicated, hardcore commercial litigators who don't have a lot of experience in arbitration. And so when it comes up when I'm sitting as arbitrator, I think, you know, Bryan's approach is the right one. I think of myself as kind of an educator and say, well, let's step back and say, do we need examinations for discovery or questioning if I'm dealing with an Albertan. Do we need that for real? Let's go through the process, and I'm going to suggest you're not going to need it. So I think of my role as kind of educating, but at the end of the day, I agree. You're the arbitrator, but you can make suggestions, exercise moral suasion, but I don't think you can be the one who's going to say, no, you're not doing examinations for discovery. But I do think, especially now as we see more and more, which is great, more and more arbitration for most sophisticated commercial parties. We've got a lot of lawyers that are being involved in arbitration that haven't seen it play out, and so don't have the knowledge of really what it is that you actually are going to need in this process. And are you going to need multiple rounds of notice pleadings at the front end? Do you need full-on document disclosure that you would have in court at the front end? And so I think of it, my role as someone as an educator. If I'm sitting in the position of counsel, boy, that's frustrating if the other side is demanding those things. But hopefully in those situations, I'll typically be the one pushing against it and hope the arbitrator's on my side. But it kind of depends, at least for me, where I'm sitting. But I think educating commercial litigators is an important part of what the arbitrator should be doing.
And I totally agree with that. In those instances, if it's disputed and the process isn't agreed, then that's where the tribunal can step in and issue a direction that makes some sense. This kind of reminds me, I guess I'm here as part of an ADRIC panel, so I'll use the opportunity to provide another plug for ADRIC, and that is the newsletter I'm the co-editor of. And it reminds me of an article that was published by Bryan Casey in the early days of the newsletter, and the title kind of says it all, and the title was, "Whose Arbitration Is It Anyway?" And so that's really kind of alluding to the point, the question that Dana had, and the proper role of an arbitrator and whether they dictate or whether they really try to use moral suasion or as Joe says, educate. And so I think that's a good article. Bryan, just in terms of a spoiler, Bryan Casey comes down on the fairly strong side of things in that article in terms of the approach that he advocates, but also does acknowledge that it is a party-driven contractual autonomy, party autonomy process.
May I add, if I may? I don't mean to suggest that an arbitrator doesn't have the authority to decide, and even against the parties, depending on the rules. But typically an arbitrator does, and that's usually protected under most laws that I'm aware of. I just happen to believe it is not necessarily the role of the arbitrator to do that in all where the parties have agreed. And I'm conscious of the fact that we can take ourselves as we want, but one thing we're not is judges. All right, we have no inherent authority other than that conferred on us by the parties and their agreement under rules. And as importantly, and again, I know this is somewhat anathema, so I'm stating the proposition blatantly, if you will, but of course it's a nuanced proposition. A judge has an obligation to society and to the rule of law and to a judicial process in ways that arbitrators do not. My primary function, I suggest, is to resolve a dispute between the parties. And yes, educating parties and counsel can be important. Yes, I'd like to exercise my authority in a way that furthers this thing called arbitration. But this thing called arbitration is just a different thing than the role and function of a judge.
Thanks, Stephen. And I think picking up on the education point, when you deal with counsel, perhaps on the other side, who are not particularly experienced in arbitration, in my experience, you'll say to them, well, why do you want discoveries? Why do we need this? And the answer is, well, we just do, right? So it's often comes from what I think is a fear of the unknown. Counsel is not sure how things will unfold without discoveries, and that's what we know, and we go with what we're comfortable with.
And just actually on that point, and this really picks up on something, Joe said, as arbitrators, I think The panel has a role to educate counsel and to really bring out the efficiency of arbitration. And this is just something Michael alluded to earlier. You are now going to, at least in Ontario, assuming the rules go ahead, the rule changes, rules of court go ahead, it's really almost the death of discovery. So really where you front load your evidence, you tender reliance documents, with very few exceptions, you have no discovery. So, you know, the plaintiff bar in Ontario, personal injury bar in particular, is up in arms about this, right? Because that was always their great weapon. But I think what you will see in the course of a few years, a new generation of counsel who are in both arbitrations and litigation, who will not be afraid of hearing without extensive discovery. Because quite frankly, you know, in 30 years, I'm not sure I've seen a case that has completely changed on some document that you didn't already know. You know, like, I mean, so I just, you know, it's so rare that you really find that true smoking gun. So hopefully there will be a new generation of people who will be more efficient. I don't know.
Cheers to the future, right? We'll see. The death of discoveries. I like that line. Oh, yes, Louise.
Louise Barrington. 30 years ago, when I first started to learn about arbitration, it was billed as faster, cheaper, more efficient, an alternative to litigation. And in the past decades, we've watched arbitration become more and more like litigation sitting down. And I think that I agree with everything that's been said about our authority and our role of teaching, because I think we have to keep in mind that it's a commercial alternative. It was devised by non-lawyers because they wanted a faster, cheaper way to resolve their disputes. And I think we have to walk a very fine line between saying, look, you don't have to do it this way. You know, it's not always like this, and it doesn't have to be like this. And saying you can't do it, which we really can't do in most cases.
One statement that I heard Yves Fortier say over and over again in arbitrations back in the day was to parties, trust your arbitrator, right? And it's easy to say, I suppose, if you're Yves Fortier, but there's something to that, of course. That's the authority invested in the arbitrator to dare to go beyond what the parties may say they want.
Bill.
Well, I want to limit my comments on this. Look, I have something to say about just about everything. But what I did want to pick up on was Joe's comments, which I agreed with word for word, absolutely word for word. And I want to bring it back to the ADRIC rules and the Sample Procedural Order, because the Sample Procedural Order really is a tool for facilitating exactly that kind of approach. I couldn't really put it more succinctly than that. If you have that approach, that it's a teaching, it's a considering what the alternatives are, and wanting to see how that whole thing goes together for people who are not familiar with it. You can't just talk about, with people who are unfamiliar with arbitration, you can't just talk about discovery in isolation from all the other aspects of the procedure to show how their concerns are going to be satisfied. So this Sample Procedural Order says right at the preamble, this is a sample. It's really meant to facilitate discussion. And if you have that approach and you have difficult counsel or a difficult opposing counsel, this is a very good way to focus that discussion.
And of course, it goes hand in hand with the checklist.
Hand in hand with the checklist and all of that. That is what these rules are trying to provide, is a tool to facilitate that discussion.
Practical springboard, basically. Get the parties going. We have about 12 minutes left here, so I think I'm going to turn us now to the matter of closing submissions, but if we want to get back into pre-hearing questioning, if we have time at the end, then that will be fair game. So paragraph 35 of the Sample Procedural Order tells us that the parties will deliver closing submissions orally, but it leaves the option for parties to deliver written submissions instead of or in addition to oral closing submissions. My personal preference as a litigator, of course, would be to always appear for closing submissions. We like to be on our feet. We watched enough Law and Order growing up. That's why we want to be here. But generally, my practice lately has been to really defer to the tribunal. And the way that we've been doing that is set out placeholders in the timetable, placeholders for written submissions and oral submissions. And when we get to the closing of the hearing, we say to the tribunal, what does the tribunal need to draft its award? In my experience, I've had tribunals say, nothing, we're good. Or, counsel, can you return for questions? I don't need formal closing submissions, but I'd like to ask questions. So, Bryan and Stephen, that's my view from having my counsel hat on, but what is your take with your arbitrator hat on closing submissions, oral, written, or both?
I think it's an important topic, both from a fairness and substantive perspective and a timeliness, efficiency perspective, to address what's going to happen and to address it early on as part of the procedural order. One thing that I'm curious about and interested in any views is that it does seem to be the practice that people talk about the possibility of closing submissions, but that's TBD, when every other thing in the procedural order is mapped out very nicely with a date and a sequence. And I don't know why that is the approach. I think it's actually helpful for everybody to know what's going to happen from beginning to end and how it'll all fit together, because it can affect not just timing and scheduling to get things done, because the alternative would be TBD means if we're convening for oral argument after the hearing, 6 months after the hearing, by the time everybody schedules get together, instead of providing for it to happen fairly shortly after the hearing, if that's what's going to happen, for instance. So just from a timing perspective, it can be important, but also from a substantive perspective, for people to know what input they're going to have to the tribunal and what form that's going to take, I think can affect the way that they proceed with their pre-hearing submissions. How extensive are they going to be? Do they hold back until the close? If there is not going to be any close unless the tribunal asks for questions, do they load up maybe a bit more on the pre-hearing submissions? So it's good to know that in advance, I think. And then also maybe even how the hearing is conducted. Do they spend a bit more time driving a point home in cross-examination because the timeline for the whole process is so short that it's been agreed that there will be no closing submissions unless the tribunal asks for it. But they have a really key point that they want to make sure gets conveyed to the tribunal nonetheless. And so I think that's one really important thing is, without talking about a preference yet, is just be clear about what it's going to be and map it all out just like you do every other part. And in terms of a preference, when I'm sitting as arbitrator, I think it depends a lot, to use Stephen's catchphrase. It depends on the counsel and the approach that's taken, for instance, on the pre-hearing submissions. I think what happens often in post-closing submissions, especially if in writing, is that there can be an awful lot of repetition and cost and time that's incurred that doesn't really help when I'm trying to draft the award. And so I do gravitate in some instances to identifying particular issues on which additional input could be helpful in terms of drafting the award.
I fully agree with Bryan's points about the importance of, to the extent possible, setting this out in advance so that people's expectations are known. I happen to agree with Emily that as an advocate, I just love the opportunity to close the case and ensure that I can engage with the arbitrator. And so let me focus on that aspect. Without a closing submission of one sort or another, there is no point at which a tribunal and the lawyers actually engage with each other on questions of law or on theory of the case. You hear the witnesses, the lawyers are there to ensure the witnesses are heard, and that's it. For me, in the abstract, but for the rare case, that's unsatisfactory. All right, I think it's important to allow the parties, and it's important to allow for the tribunal an opportunity to have decision makers and counsel speak to each other. Now, that may prove unnecessary come the end of the case. It may be that a tribunal says, really, I've got no questions for you, questions that I either don't want to put to you in writing, that you can answer in writing, or I don't see the need for a colloquy afterwards. But to me, those are the rarer cases than cases in which I think it is helpful to allow for some form of question and answer. That could be in writing, it could be orally. It doesn't need to be in person, obviously, orally. Viva voce, I mean. Voilà.
I think the more we get through today's panel, I think we probably should have named our panel Best Practices for Procedural Order Number 1. It depends.
Well, I mean, but there's a half measure. You can provide for it, you know. If there's going to be, it will happen within 2 weeks, it will happen within 3 weeks, whatever it might be, and then subject to a discussion at the end of the case, rather than leaving, as Bryan said, the entire question TBD at the end of the case, and then people realize, oh, I can't provide another writing for 3 months, or we can't convene for another 6, which is also unsatisfactory.
What I would say in terms of oral closing submissions, and it's worked relatively well to provide the opportunity that Stephen is getting at, and that is to provide for a half a day or a day at the end of the hearing where everybody is in the room together and they've put aside the schedule. It's all fresh on everybody's mind, and that can be a good opportunity for the tribunal to ask questions that are on their mind at the time, or for counsel to be able to tie in what's happened in the hearing into a wrapping up and an advocacy piece on the really key points. But that way, I think it forces, if it's provided for as part of the detailed, built-out hearing schedule, then everybody knows that that's what has to happen before everybody leaves town and goes back to whatever else that they're doing.
And I think, if I may, once again, you've put your finger on something important. As I see it, and as you've expressed it, a dual purpose to closings, style them what you will. One is to sum up, here's what we've learned this week or over the last couple of days that we didn't know before. Hopefully, we'll have learned something during the hearing. And then the advocacy portion of it. And yes, it depends, but I think both can be relevant in closing a case before a tribunal goes away and deliberates on its own. I say to fellow arbitrators when I'm on a panel that the point of by the time we finish the hearing, whether it's at the end of the evidence or 2 weeks later or the next day, we hopefully will have raised every question that we think could be relevant to us when we start to deliberate. As I said earlier, maybe that maybe that's not necessary. It's all been addressed, but that for me tends to be the rarer of the cases. There tends to be something on my mind or on a colleague's mind that's worth discussing now before we retire.
I did a drive-by on something I want to circle back on now, and that is marking this into the schedule and not using TBD. So we've got all kinds of items in a procedural order. We set out what the step is, we describe it, we attach a date to it, and the closing submissions seems to be treated often in a different way. And picking up on Stephen's point, you may provide for it and it's not necessary, or you may provide for it with a date and that date isn't workable, but that's all part of having a default that people work toward with an expectation and so on, and it can be altered. So the drive-by I gave, and I'm throwing it out to you, is why is it, if I've got it right, that there does seem to be a practice, not always, but sometimes, of people saying TBD for that part? Any ideas? Got one in the back there.
Hi, I've seen that creep up, and so I think it's been adopted probably because council thought, we won't know until the end of the hearing whether we're going to have post-hearing briefs, and arbitrators thought the same thing. I actually really like your suggestion. Why not provide for it and then make it clear that the arbitrator has the discretion to do away with it if he or she or they don't need it. And I've got it in a few procedural orders right now, and I'm going to think about whether we change that. Brad's hand just went up, so I'm going to pass
There's
the
a couple of
mic.
hands that have gone up. We've got a controversy that we've stirred up. This is awesome.
Yeah, I'm not trying to say anything very controversial. Thanks, Christina. I don't know why they do it, Brian, but I think it's probably just, does the panel want submissions, or will it just be questions, or will we be dismissed and sent on our way? But really, the reason I wanted the mic was for one thing that has been implicit in what we say. We say parties should get the process they want. I think what we really mean is the client. And I just want to give a shout out to, and lots of people are nodding, but the two most important, in my view, times where your client needs to be in the room is procedural order number 1. I mean, they need to go through that checklist with you. They need to really be sure they're getting the process they want. And I'm talking about clients that are sophisticated users of arbitration, or it's their first arbitration. But I think we really want to ensure our clients get the process they want. And at the end, closing submissions are just absolutely key for that. Like where I have lost abysmally, I have always been very happy my client was there in the room at closings, saw the questions, saw the panel wasn't getting it, whatever. But I mean, coverage for me as counsel, hugely important. But also for all of us who want to promote arbitration. You really want, don't forget the client in this, right? Because we want the client to continue to use arbitration, and that means they need to be along for the ride the whole way. And I think closings are hugely important for that reason.
Thank you for a very salutary reminder. Who pays the bills?
I have just one minor point on this. I agree with everything. I think one of the reasons for the TBD is because it's so early on when you're making procedural order number 1. And many of the procedural orders have even, optional windows for negotiation. You don't know necessarily the case is going to run the full gambit and how it's going to play out. And hopefully you have procedural conferences along the way. And so you can actually fill in that TBD over the course of the arbitration with enough advance notice to counsel and clients to know what kind of closing you want to have, and when it will be due, how it will be handled. And a second thing that has come up in some arbitrations, not my idea, but an idea I really like, if it is implemented effectively, and that is, fortuitous, is to try to avoid the post-hearing submissions being two ships passing in the night at the end of a full arbitration, to have something in the way of a sort of common table of contents, not persuasive, but just sort of, categories like these are the topics that we need to have covered. The parties work jointly and submit that to the tribunal so that when they're preparing, if it's going to be a written closing submission, the tribunal has some confidence that it's going to be covering the same material, the key material to the case. And if the tribunal has any questions, sometimes it's submitted to the parties' counsel in writing ahead of that. And I've even seen it go so far as to ask counsel, which may or may not be well received, to drop a footnote, like this is responsive to question number 2, just to sort of really remind counsel and the parties of what the tribunal has asked, because it's been a long arbitration, and sometimes some of those things fall away. They're not front of mind.
Thank you, Dana, and thank you, everyone. I am hearing Grammy stage exit music playing in my mind. But with that, we'll leave you with, one final thought. Like Bill said, these ADRIC rules, they're a springboard, they're a platform to help lawyers, parties, arbitrators create a custom tailored dispute resolution process that works for any given dispute. We encourage you to try the ADRIC rules. If you have any feedback, do let us know. Get in touch with ADRIC. But let's all continue to improve arbitration one procedural order at a time. Thank you.